we have an email question from Ken. I suffered a sprained wrist and bruised jaw in a fight at a club. The bouncers were warned that things were getting bad and did nothing to separate the parties. When the punches started, they just watched it first and then ended up manhandling people who were trying to break things up. I'm not the only one who was hurt. Are there any legal actions I can take against the club? Ken.
Man, that sounds like a case I'm pretty familiar with, doesn't it? Yeah, Ken, there is legal action you can take. Unfortunately, people get a little bit too intoxicated and they start running their mouth and somebody says something, next thing you know, there's a bar fight. Bouncers are there to protect the safety of the patrons. They're there to take the unruly people who are not behaving and get them out and separate people so people can go and have a good time. But if a bouncer gets too rough with somebody, then yeah, I mean, you could have a cause of action against them as long as they weren't doing anything, as long as they were doing something unreasonable. If they're just doing their job and they're trying to pull somebody and they're trying to separate something and they're not being aggressive or anything like that, sometimes things happen. But if they go in just throwing haymakers, or if they're punching people, or if they sit back and just let it happen, well, now they're falling down on their security job. Right. And so, we talk about negligent security. That would be an example of a bouncer basically just sitting back and letting somebody just get beat up. No, that's not their job is to stop that from happening. If they're not doing their job, they're not acting reasonably, then yeah, there could be a cause of action against a club owner for that.
Now, Les, over the years we've seen a lot of this stuff take place in our backyard.
Yeah.
Spring break, patrons get a little rowdy, a little mouthy, a little out of hand.
Yep.
And sometimes it's too much for the bouncers to have to control,
right,
and it gets out of their hands. Then you start looking at other legal actions. Did you have insufficient security at that point?
Right.
Did they know this big wave of spring breakers were coming in and they failed to act and be proactive to protect?
Did they promote it in such a way that invited that type of behavior without taking in the proper precautions with having enough security, having an area big enough to keep all these people in place versus having them wandering around, or God forbid up near roads or things like that. So there's a lot of things you have to look at. If there's an injury that occurs during some sort of an event like that, a lot of planning goes into making sure those things are safe.
Right.
But when you fail to plan,
things happen.
That's right.
Things happen.
That's right.
So, Ken, to answer your question, absolutely, you may have options, but the first thing that you need to do is find a law firm like ours that will take a case where there's been an injury involved and has a history of representing individuals against whether it's bars or festivals or whatever it may be, where there's security being provided with bouncers, and it's they're either getting too strong-armed and not doing their job.
Right.
So there is recourse there. Les, we've talked about bouncers. We've talked about auto accidents. We're talking about parties and bouncers. Mm-hmm. But we haven't really jumped into the workers' comp, which seems like it's that could happen to anybody.
That's
almost
right.
like a car accident.
Sure.
You don't have to go to the nightclubs. You don't have to go to the bars or wherever where there's bouncers. But everybody's pretty much got a job.
Right.
And we can talk about workers' comp. What happens when someone gets injured on the job and they're kind of confused about, I don't really want to tell my employer because I'm afraid I might get fired.
Right. Right. Well, employers in the state of Florida are required to carry workers' compensation insurance, which is a coverage to benefit the employees if something happens while they're on the job. It's also a no-fault type of insurance in that you could be clumsy, it could be your fault, you fell down, you stepped in a hole, you weren't watching where you were going, you broke your ankle, something like that. Or maybe you're driving a company vehicle and you get involved in an automobile accident and you're injured doing that. If you are acting within the course and scope of your employment and you're in a position that has workers' compensation coverage available, then you are automatically going to be entitled to get workers' compensation benefits to cover not only your medical expenses, but also a percentage of your wages. Depending on if you have to stay out of work for a while. But the workers' comp system is supposed to step in immediately once you have an injury on the job. But the first thing you have to do is you have to report the injury.
Right.
If you don't report it, you could have some of those benefits stripped away for failing to report it. And look, I'm not gonna sit here and say that sometimes workers' compensation claims do end up with a separation of employment between the employee and the employer.
But there's protections against retaliation.
Right,
for
but
filing the claim, though.
but there's legal protections. Somebody, they cannot fire you. It is illegal to fire you if you bring a workers' compensation claim. So there's a lot of moving parts in workers' comp. So that's another one of those things. If you've had an injury on the job, you absolutely need to get in touch with a lawyer to help you navigate that minefield. And it could be a situation where, like I said, you're injured on the job, but there's a third party that caused that injury. You may not only have a workers' compensation claim, but you may have a third-party liability claim against that individual or business and their insurance company for causing the accident.
Right.